Hello, and thank you for judging this year's Robert Lee Tullis Appellate Advocacy Competition. My name is Danny Bosch, and I am the Vice President of Judicial Relations for the LSU Law Board of Advocates. The LSU Law Board of Advocates would like to sincerely thank you all for judging this year's competition. We've had a number of sign-ups. We have 35 teams competing. We can't do this without your help, and so we sincerely appreciate you making it out to judge tonight's competition. This judge orientation is designed to bring you through the case without you having to read through the entire problem set. It's also designed to give you a better understanding of what is expected of judges in each of the rounds and what the competitors are looking for in way of feedback. So the problem is set in the fictitious state of West Hampshire, and the problem is primarily based on the opioid epidemic. So it's very timely. It's going to be very interesting to see the policy arguments that competitors can weave in. The state of West Hampshire is second only to West Virginia in opioid overdose death. Burlington is the setting of the problem. It is a small town where there has been a significant increase in opioid overdoses in 2016 and 2017. This is primarily due to prescription drugs. In order to better track prescription drugs and the use of those drugs, the state has enacted a statute that requires all physicians to report all prescriptions to a state database. That database is maintained by the State Department of Health. And as we will see, the database is an integral part of the underlying case that you will be considering from the competitors. The database is being used by law enforcement and is authorized by the state's statute. And the law enforcement officials in this case, particularly the federal and state law enforcement, in this case the DEA and the Sheriff's Office, are able to directly log into the database using credentials issued under the state statute. In way of background, all 50 states have enacted a program like this, that all 50 states have a database of this sort that requires physicians to report information such as the name, date of birth, address, prescription type, the amount prescribed, the number of refills authorized, and identifying information about the physician and the pharmacy. However, only about 30 states allow for direct access of the database. In the other states, most of those require that only the State Department of Health and other officials unrelated to law enforcement do so. And in half of the 30 states that allow for law enforcement, they also give direct login access. West Hampshire is one of those states that allows for direct login access. It doesn't require search warrants or probable cause when logging in. Under the facts of this case, following the opioid overdose rise in 2017, the DEA and the Burlington Sheriff's Department initiated an investigation into a number of doctors they suspected of overprescribing. They did so using the login credentials. There was no search warrant, no showing of probable cause, and however, all of this was done under the ambit of the state statute for West Hampshire. The search did not bring up any issues with prescribing practices. However, it did bring up some issues with patients that seemed to have an unusual number of prescriptions. It also brought up the issue of doctor shopping among many patients. This is a practice in which a patient is going to go from doctor to doctor to get as many prescriptions as possible and then use those prescribed drugs to offload them and to sell them to others illicitly. One such individual is Brittany Cooper, that is the petitioner in this matter. She has been identified for doctor shopping. She was charged using that information. She filed a motion to suppress the prescription drug records acquired from the database. In doing so, she argued that the DEA and Burlington Sheriff's Department violated her Fourth Amendment rights against unreasonable searches and seizures, and that the administrative search and special needs exceptions to the probable cause and warrant requirement did not apply to the search of the database. The government contended that individuals don't have an expectation of privacy for prescription drugs because of the fact that it is a database maintained by a third party and because that is a highly regulated industry and thus falls under the administrative search and special needs exception. The district court denied the motion for Ms. Cooper, holding with the government based on those two grounds. The standard of review here is that it is de novo because there was no warrant issued for the search of the database. The first question you'll be considering is whether an individual has a reasonable expectation of privacy in prescription drug records held in state databases of controlled substance prescriptions under the Fourth Amendment. The parties tonight will be focusing primarily on the personal nature of medical information and the fact that the database was already held by a third party. There will be sample questions for you to ask the competitors, which will be included in your packet. These are just two examples of them. More can be found within your bench brief at the back. The second question you will consider is whether the database search was a valid administrative and special needs search. At issue is whether the industry, the prescription drug industry, is highly regulated, which would justify an administrative search, and whether there was a special need to justify the suspicionless special needs exception. This is where the opioid crisis is going to come into play. Parties will specifically argue whether probable cause and a search warrant are required to access the prescription drug records, and whether an administrative search of a closely regulated industry with a special needs justification and therefore exempt from the probable cause and warrant requirements. And again, you will also have sample questions for the second issue, and those will also, more extensive ones are included again at the back of your bench brief. These are simply examples. You should note that no cases should be discussed that are decided after December 31st, 2018. Competitors can't bring them up, and we ask that you don't ask them about any that you may know of that have been decided recently. That is a competition rule 6.9. There are rules for each type of round. Right now, there are the preliminary rounds if you are judging on September 30th or October 3rd. You should note that each side has 20 minutes total. Each individual competitor will have 10 minutes. Each team argues twice in the preliminary rounds. You are considering only one of them if you are judging tonight on a preliminary round. Petitioner can reserve up to 2 minutes for rebuttal. However, that request has to be made during the course of the argument. Only one competitor may do the rebuttal, and the respondent is not allowed any time for rebuttal. This is also true for the advanced rounds. If you are judging on October 7th, October 10th, or October 14th, here are the various rules that apply for those dates. Once again, each competitor will have a time limit. We've given you some rules here that won't really apply. They're more for us, but these are for your information in terms of how the seating is arranged and how the competitors are slated. For your purposes, you should be aware that advanced rounds, the time limit does change. Each competitor has 15 minutes, with each side having a cumulative 30 minutes to argue. Additionally, the petitioner will have 5 minutes for rebuttal instead of 2 minutes. Again, one competitor may do the rebuttal, and the respondent does not have any time to rebut. The score sheet is included in your packet. There are 2 pages in the score sheet. The first is on the screen, which gives you some indication of how to score someone. It may be of use for you to give a buzzword to each competitor before you give them the points. For example, you may think that petitioner number 1 was above average or good, so you might then go into the score sheet and identify the point allocation that should go towards that specific adjective. You'll see the various weights on the screen. The knowledge of the case law and knowledge of facts are the most important here. However, there are also weights given to style, presentation, court manner, and also to time efficiency and management. Your role as a judge is to rate the competitors first and foremost. It is a competition and we have to move on, and unfortunately people must be eliminated. So please take that under advisement that at the end of the day someone does have to win this competition. While we think everyone is great, that is the paramount objective. You can use the general scoring rubric. Please do not score anyone based on the actual merits of the case. Unfortunately, some cases are subjectively or objectively may be slated to one side or the other. If you think that that is the case, you should not be evaluating each side based on whether they actually would have won. They haven't chosen the side that they are arguing. So please only judge them on stylistic critiques and whether they made lemonade out of lemons. We ask that you please give them as much feedback as you can, both written and verbal. You'll have the opportunity to write feedback on the second page of the score sheet. Don't give any specific case advice or how to treat a specific fact within the problem set. Please limit your advice and your critiques to only that of how they should be doing stylistic courtroom treatment and the like. Please also don't comment on things such as appearance, hair, facial appearance, and accent, religious clothing, or last names. Thank you very much for your time, and we hope you enjoy the competition tonight.